of the county clerk or the Board of Election Commissioners. This will require testimony by a representative of the county clerk's office or the production of certified copies of those relevant records. Voter registration records shall be kept by the local election board, such as the absentee ballot eligibility printouts are not proper evidence. So again, it needs to come from the Cook County Clerk's office. The board, if it chooses, may appoint a hearing officer to hear some of the more complex issues, to take evidence and render a decision. The electoral board decision will be in writing and will specify which objections, if any, have been sustained by this board. The decisions will be voted on in open session by the board. Unless we can draft the order during the brief recess, and we may take recesses, we will have to reconvene on a different day to open session, vote on the decision, and tend to the order. Until the decision is in writing, it is not a final decision. The board will give copies of these decisions in open session to all of the parties. And as I mentioned, the parties will have 5 days to file an appeal of the board's decision with the circuit court if you think a mistake has been made or you're unsatisfied. Lastly, the board may consolidate cases. So if we have similar cases submitted by different objectors, we may consolidate those. Everyone should state and spell their name, as Ms. Gandersky mentioned before we started this meeting, so we get that properly recorded in the court record. And then lastly, I would ask the clerk or someone from the clerk's office if they would maintain minutes as well, even though we have a clerk reporter here, if we can have somebody maintain the minutes for this meeting. All right, so we're going to move now to item number 4, which is the appointment of Kelly Gandersky as counsel to the board. Is there anyone that would like to move that motion?
I move approval.
Second.
Okay.
Ms.
So
Alderman Nguyen.
I've got it, Clerk Reed. Alderman Nguyen, right now you're just an alternate. So if there's a case where we have to have you in, we'll have you in then. So I'm going to second that motion of Alderman Rainey's. Is there any discussion on this? All right, seeing no discussion, all in favor of Kelly Gandersky serving as the counsel to the board?
Aye.
Aye.
All right, so on a 3-0 vote, Ms. Gandersky will serve as the counsel to the board. Ms. Gandersky, if you just want to share so people understand Alex Ruggie, her role in this, because I know she's here with your office. Does she have a specific role?
Yes, Ms. Ruggie, I asked her to be here today to prepare template orders in case the board is ready to render a decision today. So she's just here listening to keep track for me and take some notes in the event that we are able to render an order today. So because we're operating virtually, it's a little bit different, but Ms. Ruggie, you can go ahead and stop your video, and if we need to call upon you, we will.
All right, thank you, Ms. Gandersky. Also, I didn't mention this when I ran through the list of different items. I am here at City Hall. One of the members of the electoral board needed to be here at the Civic Center. So I am here. I'm actually in the mayor's office, not in city council chambers, as you see behind me, but I'm in the building. We're next going to move to item number 5, which is adoption of the rules of procedures for the election.
I move adoption.
Okay.
Second.
Is there a second?
Second.
Yeah, Alderman Rainey seconded. I'd like to discuss very briefly and make maybe a motion to amend one of the rules. One of the rules says that the Corporation Council has the authority to appoint a hearing officer, and I just think that should be maintained by the board. And so I'd like to amend that rule and just the board itself appoints hearing officers.
If the board would like to do so, I have no objection to that.
I have no objection.
So I make that motion as
move that motion to amend.
I move the motion to amend the rules to allow only the board to appoint a hearing officer.
Second.
May I ask a question?
Go ahead, Ed. This is Ed. This is just introduce yourself so the court reporter can record this.
Sure. This is Ed Mullen. I'm an attorney representing a number of the objectors here today. My only question is on your website, I see the proposed rules or the rules that were adopted in 2000 in the last hearing. I don't see the proposed rules. Are those publicly available somewhere?
The rules that should be posted are the rules that are being adopted today. Those might not have been posted yet because they were just about to be adopted. So
Are they in the agenda?
they were probably not included in the agenda.
Oh,
because
okay,
they haven't
okay.
been adopted yet.
Yeah, so I just haven't seen those rules yet.
Is it possible, can we get a link here in the Zoom or somewhere to distribute those to everyone now that or once they're adopted? Kelly or Luke?
Yeah, they can get posted as soon as they're adopted.
Okay.
All right, so we'll get those a link put up here so everyone can have those rules as soon as they're about to be adopted. Alderman Rainey.
Would you give us some reasons why we would appoint a hearing officer?
I can answer that question. If it's a complex area of law where it's not a straightforward typical objection. So as you may know, there's a long line of case law for your ordinary objections that one might make. There are some objections that might be new or they might be in a gray area of law and might require extensive evidence to be taken, maybe more than the board may feel it is equipped to handle. In that event, the board may want to appoint a hearing officer who is an Illinois licensed attorney, who's adept and experienced at taking evidence and conducting hearings to do so, because it's usually something that would take an extensive period of time.
And if I may add to that, Alderman Rainey, typically in larger jurisdictions like Chicago, where there are many objections, it wouldn't make sense for the board to individually hear all of those cases. So Chicago and other larger jurisdictions appoint hearing officers to hear the actual case and then recommend to the board final action.
All right, but at the end of the day, per this amendment, the board would have to vote that they want to have outside hearing officer. So Clerk Reed moved the motion. I seconded it. Any further discussion? Okay, seeing none, all in favor of that amendment?
Aye.
All right, so on a 3-0 vote, that's amended. We had a motion and a second to adopt the rules. So
one last question regarding the rules. Apologies. It does also say that the board will not consider whether or not an objector has firsthand knowledge of, and I'm sorry, this is Clerk Reed speaking, Ms. Hickey, whether the board has firsthand knowledge, or I'm sorry, whether the objector has firsthand knowledge. I do just want to make sure that the board especially if we're going to request a records examination, that, the objector doesn't have to have firsthand knowledge, but somebody should have firsthand knowledge if we're going to do that. So I just want to make that clarification, and then with that,
That would be correct. So what we're looking at on the objection is the four corners of the objection. While the rules of evidence should be followed, they're more loosely filed as this is quasi-judicial. However, you are correct, Clerk Reed, that someone, if there is a question of fact, the person testifying should have firsthand knowledge, or someone substantiating the claim should have firsthand knowledge. But the board really should just be looking at the four corners of the objections at this point.
yes.
all right, so we've got the amendment that has been passed 3-0. I know we have a motion that was seconded to pass the adoption, or to adopt the rules of procedure. All in favor of adopting those as amended?
Aye.
Aye.
All right, so on a 3-0 vote, the rules are adopted as amended.
Mr. Mayor,
Those are gonna be posted by our city attorney staff for all of the different parties. So you'll get those shortly, and we'll post those on here in any other public location. Let us know, Kelly Gandersky. Yes, Clerk Reed.
yeah, I just wanted to make one suggestion to change the order of the the agenda a bit. We have, just to keep a continuous flow, I think it would make sense to do, for example, item number 9 last. So when this board, when this board potentially convenes, that it's just a clean switch of board members.
I was
So
actually
just
going to,
moving-
I was actually going to suggest we do item number 9 first, because
okay, and
then
same-
Alderman Nguyen doesn't have to spend the next 4 hours or however long we spend at this meeting here. That was my thought.
yeah,
But why don't
perfect.
we go through these? Why don't you let me go through these, Clerk Reed, and see if we can't get this. So let's just recognize, and I want to make sure we have the parties here for all of these different cases. So this is one election board meeting, and we have several different cases. I believe there's 6 in total. The first one is case number 20-MOEB-EV-02, which is Willie L. Jefferson versus Rebecca Mendoza. Is Willie Jefferson with us, or his or her attorney?
Good morning. This is Ed Mullen, M-U-L-L-E-N, on behalf of the objector, Jefferson.
All right. Thank you. Thank you, Ed. Do we have Rebecca Mendoza, or representative, an attorney for Ms. Mendoza?
Yes, good morning, Rebecca Mendoza here this morning, R-E-B-E-C-A-M-E-N-D-O-Z-A.
All right. Thank you. In this case is involving the 5th ward of Evanston. The second other case, or again, we're going to go through all cases, just making sure we have the parties here, and then we may do a little reorg here to make this as efficient as possible. The second one, which is number 7 on our agenda, is case number 20-MOEB-EV-03, which is Miles Davis versus Eric Young. And Mr. Young is running or has submitted petitions for the 3rd ward. Is Miles Davis, or an attorney for Miles Davis, here?
This is Ed Mullen on behalf of Miles Davis.
Okay, so Mr. Mullen's going to represent there. Okay, how about Eric Young?
Present, ERIC-YOUNG.
All right, welcome. Thank you, Eric. The next case we have is case number 20-MOEB-EV-04, which is Allison Harned versus Jane Grover. Do we have Allie Harned, or an attorney for her, present?
Good morning. This is Ed Mullen on behalf of Allie Harned, and Ms. Harned is also on the call as well.
All right, thank you, Mr. Mullen. Do we have Jane Grover, an attorney for Jane Grover?
Yes, I'm here. Jane Grover, Janegrover. Thank you.
Okay, thank you. Case number 9 is number 20-MOEB-EV-05, Tom Osser, etc., versus Shelley Carrillo. Do we have Mr. Osser, or an attorney?
Good morning. Andrew Finco, F-I-N-K-O, appearing for the objectors, Tom Osser and Nicole Mitchell-Hall.
Okay, thank you, Mr. Finco. Do we have Shelley Carrillo, or anyone representing Ms. Carrillo?
Good morning, I'm here. My name is Shelley Ann Carrillo, SHELLEYANNCARRILLO. I'll be submitting a pro se appearance via email.
Okay, thank you. And the claim, Ms. Carrillo, on the objection to yours was that you didn't identify an office. Could you just share with us, was there a specific aldermanic office you were running for?
8th ward.
8th ward.
And it is specified.
Okay, all right. We'll
The
get
ward
to
that I reside in is specified.
Okay, all right, thank you. All right, next one, number 10 on our agenda, is case number 20-MOEB-EV-06, Catherine Whitcomb, etc., versus Eric Young. Do we have Ms. Whitcomb, or I know there were several parties there.
Yes, Mayor Haggerty, David Foster here. I'm appearing as counsel for Catherine Whitcomb. And for 5 other co-objectors. The name is David, D-A-V-I-D, Foster, F-O-S-T-E-R. Catherine Whitcomb is on. I haven't seen whether other co-objectors besides Ms. Whitcomb are on.
Okay, thank you. And then Eric Young, I know you're here because we had an earlier case. Go ahead, Eric.
I was just to say present, E-R-I-C-Y-O-U-N-G.
All right, thank you. All right, and then the last one we have is case number 20-MOEB-EV-07, which is Evie Krause Russell versus Eleanor Ravel. Do we have Ms. Russell and an attorney for Ms. Russell?
Mayor, I have an Andrew Finko that was listed as the attorney. Is Mr. Finko?
Yeah, Andrew Finko here for the objectors.
Oh, so you're here for Evie Russell?
For Evie
on this case.
Russell.
Yep.
Yes.
Got it. Thank you, Andrew. All right.
Thank you.
All right. And then do we have Eleanor Ravel or an attorney for Eleanor Ravel?
Yes, this is Michael Kreloff, attorney, representing Ms. Ravel. Ms. Ravel is also, I believe, on the Zoom call.
All right. Great. Thank you. All right. So we've run through all the cases. We have 6 cases. I would recommend that we hear case number 9, which is Tom Osser versus Shelley Carrillo. I would recommend we hear that one first. So that way, Alderman, if you two, because she's claiming that she's running for the 8th ward, both of you are also running for the 8th ward. I'd recommend we substitute in Alderman Nguyen on this case.
I second that.
Well, we don't, yeah. We just have to, recuse ourselves. So go ahead, Alderman, Ms. Ganderski.
Yes, Clerk Reed and Alderman Rainey, both of you are disqualified from hearing this case. The alternate, Alderman Melissa Nguyen, will hear this case with Mayor Steve Haggerty. So I'm going to ask both of you, Alderman Rainey and Clerk Reed, to stop your video so that we can see Alderman Nguyen with Mayor Haggerty. And then I am going to ask that counsel for Tom Oster et al. Please again state and spell your name for the record.
Good morning, Andrew Finko, F-I-N-K-O.
And Ms. Carrillo, are you available? Please turn on your screen. Okay, Ms. Carrillo is present. Ms. Carrillo, if you plan to testify, I'm going to ask that you raise your right hand. And do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Let the record reflect that Ms. Carrillo is present and has been sworn. Mr. Finko, do you intend to present any witnesses today?
No.
Okay, so I believe all of the parties have been sworn. Mayor, I will leave it to you.
So per our rules, and correct me, Ms. Ganderski, because I know you're certainly more in depth with all these rules than I am, but per the rules, the objector has up to 10 minutes to present your objections. Mr. Finko, on behalf of Tom Osser, at that point, Ms. Carrillo, you'll then have 10 minutes, okay, to refute that objection, and
Yes,
then look, just give me one second on the process, and then Mr. Osser will have a opportunity for rebuttal. Is that correct, Ms. Ganderski? And how long is his rebuttal? How much time does he get?
That's correct. We should limit the rebuttal. Let's limit the rebuttal to 2 minutes thereafter. I would also state this, that if I would ask before we begin, are there any preliminary motions by either side?
Yes, I have a preliminary motion to dismiss the objector's petition.
Okay, are you filing
Yes,
to dismiss?
Absolutely. I filed the motion and I would ask that the board rule on that motion.
Okay, we did not receive your motion. So where did you file it to?
I filed it to law@cityofevanston.org. and to the representative of the objector. And to
I
the
did
city
not
clerk.
receive a motion.
Okay, so the motion has not been received, Ms. Carrillo.
They were filed via email.
I understand. Let me finish explaining.
Sure.
So it should be filed with the clerk's office. You can also send me a copy via email. I can give you my email address.
Please.
So if the board wants to, if your motion is already, well, if you're trying to file the motion, she was trying to file the motion, my recommendation is to the board is to receive the motion. I don't know if we want to pass the case to see if we can review the motion quickly and come back to the case, or if you want to reconvene at a different date to review Ms. Carrillo's motion.
I mean, I think I think we're not going to get through all of these cases today, meaning, reaching a conclusion on all of these. So I think there is absolutely at least going to be one other meeting, if not 2 or 3 other meetings. So I would say, since Ms. Carrillo's motion hasn't been reviewed yet, and the objectors haven't had a chance to review it, that we set this for the next meeting. And so everyone has a chance to review her motion to dismiss, and then we'll hear that motion and then hear the objection at that time.
I concur with that.
Okay, let's, Ms. Carrillo, I'm going to put in the, I'm going to send you, well, what is your email address? And I can send you mine, or I'm just going to announce it. Just because we're meeting virtually, I want to ensure that due process is met. So my email is kganderski, KGANDURSKI @cityofevanston.org. Also, please make sure you file your motion with the clerk's office as well. And Clerk Reed, can she do that by email?
Yes, Luke shared it in the chat there. It's cityclerk@cityofevanston.org.
Okay. And then Mayor Haggerty, I don't know if the board wants to pick a date to reconvene now, or if you want to wait till the conclusion. It is up to you. It should be a short continuance.
Why don't we go ahead and pick a date now. And I agree it should be short. So I'd like this meeting to occur again this week. Is 2 days enough if we did this on Wednesday morning? I'm just looking. Actually, I'm sorry. Wednesday does not work for me at all. We are in the Emergency Operations Center for the City of Evanston with the pandemic. How about Thursday morning at 9 a.m.?
Yes, Mayor, I am available on Thursday at 9 a.m.
Okay.
I can make myself available at 9 a.m. This is Shelly Ann Carrillo too.
Thank you, Shelley. Okay.
Okay. And Mr. Mayor, may I ask if the objectors could get leave to file a response after I receive the motion to dismiss, a written response?
So Ms. Gandersky, you want to?
So Ms. Carrillo, her motion's been filed. I just haven't received it. Please send courtesy copies to Mr. Finko. Mr. Finko, you might need to give Ms. Carrillo your email address. I had asked Mr. Finko that you file your response by tomorrow.
I have it.
Oh.
It was sent to his email as well.
It's finkolaw@fastmail.fm. It is typed up on the page 4 of the objection at the bottom.
All right.
Yeah, I sent it to that email address.
I have not yet received the objection, so if you could please resend that, Ms. Carrillo.
Absolutely.
Okay,
Thank you.
in council, I'm going to ask that your response be filed by close of business tomorrow with the clerk's office and with my office as well, to my email address, with courtesy copies to Ms. Carrillo. I will ensure that the board receives copies of everything.
Sounds good. Thank you.
Thank you.
All right, so this meeting that will be continued on Thursday at 9 a.m.
Thank you.
Understood. Thank you.
All right, thank you to both the parties. Thank you, Alderman Nguyen, for being an alternate and filling in on this. We're now going to move back to the rest of the agenda, which means we're bringing back Clerk Reed and Alderman Rainey. Clerk, do you have something?
Yeah, I was wondering if we can start with the case Catherine Whitcomb, case number 10. Since there's a bit more to it than some of the other objections, I think it's.
I'm also going to advise the board, if they would like, it's the board's choice. If there's any matters that are similar and consistent, all against the same respondent, the board may consolidate the actions as well and hear all of them at the same time. That's up to the board.
Yeah, I was gonna suggest consolidating case number 7, which is Miles Davis versus Eric Young, with Catherine Whitcomb versus Eric Young, because they're also alleging the same violation of rules.
If I may object to that, there are differences. I mean, there is one of the objections that is similar, but they're also represented by 2 separate attorneys, I believe. Yes, they're represented by 2 separate attorneys. And I think it'd be fair to give,
Well, they'd all get to speak. They'd all have their opportunity to be heard. It would just be that we're hearing it all at the same time as opposed to ending one and then going to the next hearing. So everyone would.
May I be heard on this as well, please?
Sure, Ed, go ahead.
So this is Ed Mullen. I represent Mr. Jefferson, who is objecting to Mr. Young's petition.
That's Mr. Just so we're clear, it's Mr. Davis on that one, Ed.
My apologies for mixing those up. In the objection against Mr. Young, which is solely based upon the issue of the binding of the petitions, and is a very simple and short objection. The other objection that's filed has 3 additional objections, some of which are going to require significant legal briefing, and others of which I believe will require evidentiary hearing. And I think it would be both for the record that we would need to create if there's the necessity for an appeal of our objection, as well as I believe the other objection will take a significant amount of time in addition to what our objection would take. And I think it would be unfair to my client to have him have to have me present for significant argument that he is not a party to.
Thank you. Alderman Rainey, do you have any thoughts on this?
The only thought I have is I'd like to be clear on who's running this meeting, and if we could just move forward.
All right, thank you. All right, so having heard from different people on this, we're going to go ahead and keep these as separate cases. We won't consolidate them, because I do think there's something to be said if a party wants to appeal, that there's a specific record for that.
I agree with that.
All right. So,
may I make a motion to hear case number 20 MOEB-EV06?
Is there a second for that motion?
Second.
All right, then we'll go ahead and you will hear that motion first then. All right. So we will start with the objectors on this. Objectors are represented by David Foster as their counsel. Mr. Foster, you'll have 10 minutes. I will ask our city attorney or her deputy to keep track of the 10 minutes. After.
Sorry.
Go ahead, Eric.
Sure. I still have not been served. I received an email yesterday at 6 p.m. from Kelly Gandersky telling me that our meeting is today. So in regards to, this is the first time I'm seeing that Miles Davis is an objector to me, and it's less than 24 hours. I'm just going to ask that I join the continuance on Thursday.
Okay, I'm gonna jump in here. First of all, this is Kelly Gandersky. The agenda has been posted since Friday with all of the objections, and I sent you the agenda yesterday. The sheriff has made due diligence in attempting to serve everybody. If the sheriff couldn't serve you for whatever reason, I don't know what that reason would be, but notice has been posted. These hearings are on a short statutory timeline for a reason. If you had an opportunity to review it when I sent you the agenda yesterday, So I'm going to advise the board that we proceed today unless the board agrees to a continuance. But so first I'd like to take care of that housekeeping matter. Second, after that, I'm going to ask both parties to introduce themselves to the record. Again, I'm going to remind everybody we have a court reporter. So jumping in on screen and talking out of turn is going to be terribly confusing for this record. I'm going to ask that everybody be respectful of that rule. Second of all, after the board rules on whether we are going to hear this case today, I'm going to ask the petitioner, Mr. Foster, and the respondent, Mr. Young, if they have any preliminary motions before we begin. So board, first, I'm going to leave it to you whether you wish to entertain a continuance in this case.
I would say, I think it makes sense to move forward. These are, as Ms. Ganderski said, time-sensitive matters. And Mr. Young is here today, so he's aware of it beforehand. I think we should move forward.
I agree.
All right, so we're going to go ahead and move forward. And Ms. Ganderski, because there's all sorts of protocol that we want to make sure we follow for the courts, if there's any objections, why don't you go ahead and run each of these cases, okay?
Very good. So I'm going to ask the counsel for the petitioners, please state and spell your name again for the record.
Yes, David Foster. My name is spelled David Foster, and I'm counsel for the petitioner objector.
Okay, Mr. Foster, will you have any witnesses to present today?
It depends. I was going to try and simplify things for the board by asking for a stipulation as to the format of Mr. Young's papers when they were filed. I don't think there's going to be any dispute. I've seen a photograph submitted. I believe there's no dispute that they were submitted in loose form in a manila folder without any form of staple, binding clip, paper clip, or other mechanism for attachment.
Okay.
So
So you have,
I would start by asking, do we stipulate
so
that?
at this time you have no witnesses. Okay.
Not unless needed, Ms. Ganderski, because there's a dispute on that point. I think it's undisputed.
Okay, I understand. Mr. Young, do you please state and spell your name for the record?
My name is Eric Young, ERICYOUNG.
And Mr. Young, do you have any witnesses to present today for the hearing?
I do not.
Okay. That being said, are there any preliminary motions, Mr. Foster or Mr. Young, aside from a continuance?
No motions for me.
None.
Okay, so Mr. Foster, I'm going to ask you to present the case in chief. You have 10 minutes.
Thank you very much, and thank you, Mayor Haggerty, Clerk Reed, and Alderman Rainey. I'm going to try and just do two things this morning. I tried to be fairly detailed in my petition so that all of you have the exact terms of the objection laid out in full in writing already. I think there's a couple of things that need to be emphasized, though, that I'm going to bring out this morning. And I'll take it in the order of the objections. The first objection is the failure to bind. I do want it clear that we're not going to have a fact issue on this. And so I would ask Ms. Ganderski, since you're serving effectively as our judge, if you would request.
No, I'm not serving as the judge. The board is the judge. I'm just here to advise the board.
Okay. Well, I think to simplify things, I would ask that Mr. Young stipulate that his papers were filed in loose form in a manila folder without a staple, without a binding clip, without a paper clip, or without another form of attachment mechanism.
Okay, before we begin with that, I'm going to ask Mr. Young to please unmute his microphone and please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth so help you God, Mr. Young?
I do.
Please let the record reflect that Eric Young has been sworn. Mr. Young, do you care to stipulate to Mr. Foster's statement as to how the petitions were filed?
I do not.
Okay, Mr. Foster, you do not have a stipulation then.
Well, then I would ask to call Eduardo Gomez.
Okay, is Mr. Eduardo,
I'm sorry, I didn't hear that. I didn't hear what you said. I'm sorry, Mr. Foster. Could you say that again?
Yes, I would ask to call Eduardo Gomez, who is the deputy city clerk.
okay, is Eduardo Gomez here today? Mr. Gomez, if you're here, please turn on your camera and your microphone.
Hi, Kelly. This is Eduardo Gomez, deputy clerk.
Okay, Mr. Gomez, you've been asked to be called as a witness. So I'm going to, since you're here, I'm going to swear you in to testify. Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, let the record reflect that Eduardo Gomez, Deputy City Clerk, has been sworn as a witness, and for the record, his name is spelled Eduardo, last name Gomez. Mr. Foster, he is your witness. Mr. Young, you will have time to cross-examine Mr. Gomez as well.
Thank you. Good morning, Mr. Gomez. How are you this morning?
I'm good. Good morning. How are you?
I'm well, thank you. You are the deputy city clerk in the city clerk's office of City of Evanston, is that correct?
Correct.
And in that role, were you responsible for receiving the filing of certain of the petitions for candidates in the upcoming municipal elections?
Yes.
And in that role, were you the official who received the filing of Eric Young's petitions on November the 23rd of 2020?
Yes.
Would you describe for the board, please, the form of those petitions when they were submitted by Mr. Young?
Yes, they were submitted inside a manila folder to me with no binding.
Were the petitions stapled in any way?
No.
Was there a binder clip on the petitions?
No.
Was there a paper clip on the petitions?
No.
Was there any other form of attachment device securing the petitions together?
No.
Thank you, Mr. Gomez. No other questions.
Okay, before we turn it back over to Mr. Foster, Mr. Young, you have the opportunity to cross-examine Mr. Gomez on the testimony that he just presented. Do you wish to ask him any questions in response?
No.
Okay, Mr. Young has waived his right to cross-examine. Mr. Foster, you still have the floor.
Very good, thank you. What I'd like to emphasize this morning is that the requirement for binding is absolutely clear in the statute and the case law as a mandatory requirement. And it's absolutely clear that strict compliance is required. Now, there's also case law that then addresses what it means to strictly comply. There is a case that went so far as to say that a paperclip on a small group of petitions, 5 or 6 pages was the total submission, that had apparently some form of serrated edge on the paper clips, which prevented the petitions from being pulled apart when they were tested by the board, that was held to satisfy the standard. But what that court made clear, and every other court that addresses these requirements for format of petition makes clear, is that if a candidate fails entirely to make any effort to comply with the form requirements of the statute, that is not enough. That does not satisfy the statute, and the petitions have to be rejected. That's clear Illinois law. Now, so that's the situation we face here. There's not an ambiguity. There's not a factual dispute. These were loose papers. They were attached in no way, shape, or form. And so where there is no effort, the binding requirement is not met. And the candidacy papers have to be rejected. Now, I want to raise a couple of points besides the legal points, but we do have to keep in mind this is preparatory to potential legal proceedings. if there were to be a challenge on either side. But there's some policy issues that I think we need to keep in mind here. What's the purpose of this binding requirement? Purpose is to protect the integrity of the electoral process. Prevent the possibility that somehow after the petitions are filed, there's an addition, subtraction, a substitution. This is a provision that goes to protecting the integrity of Illinois elections. So we shouldn't view it as something that somehow is, can just be written off. When there are issues of protecting the integrity of the system, protecting against corruption, it's important that we pay attention to those rules and that we respect them. Now, a couple of other points. The fact is, complying with these rules for filing takes effort, but it's doable. And I think it's particularly doable this year. Our city clerk issued a very good presentation overview, giving step-by-step instructions as to how to file candidacy papers, and they clearly say that they must be securely filed. The Illinois State Board of Elections has issued a very nice how-to manual that says the same thing in even more detail and more clearly.
Can I
And
say something? I'm sorry, can I say something really quick? I'm sorry, Mr. Foster. Can you stay a little closer to your computer? Sometimes when you back up, you trail off a little bit.
sure,
Thank
okay.
you.
Sorry, is there anything you need me to repeat, or are you all right, Ms. Hickey?
No, I'm good.
All right, thank you. And it's not just in the guidebooks, it's right there in the petition itself. The petition right at the top says bind here in all capital letters. And so this is not a difficult requirement to comply with. Finally, I want to talk about, just as a third policy matter, the temptation sometimes when there are rules that have serious consequences, there's a temptation to say, well, it's not necessary to follow it here. Problem if we go down that road is we end up in a really problematic place. We end up the next time having real difficulty in insisting that the rules be applied. And pretty soon we get to a point where the rules are simply regarded as optional. It's like what happens when the police stop enforcing a speed limit. That's what happens if no one would pay attention to stop signs. It puts the system at risk with this particular provision of finding that someday we put ourselves in a position of having tampering, of having slip sheeting, of having additions or subtractions after filing. We don't want to go down that road as a matter of policy, good public policy to protect the integrity of elections. And nobody can go through what we've gone through in the last month with
Mr. Foster,
elections.
just quickly, your time is up.
Oh my gosh.
Okay, Mr. Foster, why don't you just finish your sentence, and then we do have to give Mr. Young his time as well.
Okay, I apologize. And what I would simply say is we can't go through what we've gone through in the last month without realizing the importance of election officials who faithfully and diligently comply with application of the law and do so without favor or partisanship. That's critical to the integrity of the electoral process, and we all need to keep that in mind. Thank you. I would ask that otherwise the municipal board look closely at the petition objections. I think everything there is laid out quite well. I would ask that there be a finding, as a matter of fact, proven by the preponderance of the evidence, that the petitions were not bound in any way as submitted. Thanks very much. And if you have any questions, I'm happy to take them now or later.
Thank you, Mr. Foster. Mr. Young, you have 10 minutes. So you can discuss your response to those arguments. And
Motion to
Ms. Ruggie, would you please set the clock?
motion to bring in counsel, please. You're represented by counsel.
I would accept that. I mean, Ms. Kandersky, I would accept that motion.
Again, it's up to the board.
If he's bringing counsel today and we're going to continue in this moment.
Yes.
That's fine. That's fine.
All right, and I'm going to suggest this as a matter of procedure. If any of the respondents who do not have counsel wish to obtain counsel, that motion really should be made before we begin. This is, we are on an expedited schedule, and I'm going to ask that everyone be respectful of that. This is not set by the board. This is not set by me. This is set by your Illinois legislatures. So, so there was a motion to continue for counsel. Clerk Reed says he will accept that motion. I don't know if the board wants to second that and move to continue, or if you want to keep proceeding today.
All right, let me be clear on something. I thought that Mr. Young said he had counsel here and just asked that his counsel speak. Is that correct, Eric, or were you looking?
Correct.
Yeah, that's correct.
Correct.
So
it wasn't continuing.
We're saying that we're fine with having Eric Young represented right now by counsel that's going to speak on his behalf, Kelly.
That's fine. The council will announce him or herself, and please file. I expect that everyone today will be filing their appearances if they haven't done so already with the clerk's office and copying me on the email. So who is counsel for Mr. Young? Please speak up.
Yes. Good morning, council, and good morning to the board, to the mayor. This is David Dale, last name D-A-L-E. I can start my video if you grant me the opportunity.
Of course. Mr. Dale, please open your video.
Good morning to the board and to the mayor and to council as well. And again, I want to apologize for my casual appearance this morning, but let's attribute that to the crazy times that we're living in, as well as the fact that Mr. Young notified me about this hearing last night, I believe, when he first received informal notice. But thank you for the opportunity to appear. Council, I will file an appearance and make sure that I circulate copies as you directed. So good morning.
Mr. Dale, you have 10 minutes. Ms. Ruggie, please set the clock.
So first, I would want to reiterate Mr. Young's motion. I'd like to make sure that that's put onto the record. I believe Mr. Young initially made a motion regarding service of process and a lack of actual due process provided to him. Under the election law, Mr. Young was required to be served with process either through certified mail or through the sheriff. I believe there's some comments made earlier in the meeting that I heard that efforts were made by the sheriff, but I think what's clear for the record is that no service was ever made. So Mr. Young's limited appearance and initial objection was based on a jurisdictional objection and on a process objection. I understand we're operating under an expedited schedule, but that doesn't mean that we waive the obligations to provide process to our petitioners. So I'd like to reiterate that motion. I'd like the opportunity to brief it and to provide a quick written response. I heard earlier that a respondent was allowed 48 hours to provide that written response. I believe I could provide that exact same response in that same time limit. That's the first thing I'd like to put before the board.
I would.
Okay. Go ahead, Clerk.
I think I would deny that motion. As Mr. Young is here, he's been notified. He was able to retain counsel last night. That would make a motion to deny that.
Okay. Just so I understand, the motion to deny is based that in less than 24 hours time, you're saying the petitioner should have been able to get himself ready and to file a written response to these objections and to prepare for a hearing with less than 24 hours notice. Is that that's the argument?
May I have an opportunity to speak momentarily? Please, this is David Foster. I'm not sure, Mr. Dale, what it is you're saying when you say you weren't served. I served your client, Mr. Young, by email. I know it's a good email for him. I got no bounce back from the email. And so and in fact, the rules of this board is adopted in 2018 and is readopted just now.
Mr. Foster, you're
This year, Ms. Gandersky as counsel to the board, and I serve Mr. Young at eyoung54@gmail.com. So if the service question that you're raising is a question as to whether electronic service is adequate, I would object to any kind of delay for addressing this, because that's a question of law that I think the court can address immediately.
I'm going to stop everybody just for a second. Clerk Reed made a motion to deny the continuance. Is there a second from the board? There's no second on the motion. So, well, I guess I'd ask the board, are we proceeding today? Clerk Reed made a motion. There's no second.
There was no second, so that means we're,
I guess someone would make a motion to grant the continuance.
it would, but I have a question, Ms. Gandersky. Can you talk to us about what serving means? I mean, Mr. Foster just said, hey, I sent an email. It was a good email address, but what does it mean to be officially served when it comes to challenges that objectors have of candidacies?
So again, this is all, we're on an expedited schedule per the state statute. And so the state statute requires that the city only make its best efforts to attempt to serve. We sent everything to the sheriff's office. We sent everything by certified mail. If service was not effectuated, that's not on a default of the city or a lack of effort on the city. Mr. Foster, I believe, is just trying to bolster the argument to say that in addition to that, he sent service via email to Mr. Young, which I think matters not at this point. The main point is whether or not the city made its best attempts to serve. Mr. Young is here today, and I can attest to the board as an officer of the court that I sent the agenda to Mr. Young yesterday via email when he requested it. So the email was sent with the agenda. The agenda contained the objections. Mr. Young has counsel here today. So if I'm advising the board, it would not be improper to proceed today. It is up to the board whether the board wants to grant the continuance.
If I may respond very briefly to Ms. Gandersky's comments, my first question would be when. Ms. Gandersky says that she attempted to serve Mr. Young through the sheriff and through certified mail, but has given no indication as to when. If she's going to hold the standard to an expedited best attempt or best attempts policy, then we would at least like to know when she tried to make this service. If she tried to make it on Saturday night, that's obviously not best efforts. The fact that Mr. Young never received a certified mailing, which should have come within a few days if service was made in a timely manner, is evidence that maybe Ms. Gandersky has not made best efforts to serve Mr. Young. And the fact that he's appeared today because he emailed her having received less than 24 hours notice that this hearing was going to take place, I think is evidence only that he wanted to protect his rights, not that he was submitting to jurisdiction. His very first motion was one regarding a lack of service. He's obviously objecting on a very limited jurisdictional issue.
Ms. Ruggie is also here. She is Assistant City Attorney, and she is also an officer of the court. Ms. Ruggie is the one who personally went to the sheriff's office. Ms. Ruggie, can you state and spell your name and attest to the attempts to make service?
Yes, thank you, Ms. Gandersky. My name is Alexandra Ruggie, Alexandra, Ruggie, Ruggie. Again, I'm an assistant city attorney with the city of Evanston. I went to the sheriff's office on December 3rd. I can see from the sheriff's website that an attempt was made on Friday, December 4th to serve Mr. Young. Additionally, all items were mailed out on the 3rd via certified mail. These are the requirements per the election code. The city has limited timing as to when these items must go out. The mayor was served with the objections, and the city had 24 hours in order to send these out. And the city did comply. Additionally, we then have a limited option of how many days we must hold the hearing by, and that's why the hearing was scheduled for today based on the statute.
Thank you, Ms. Ruggie.
I'd also like to note, I guess this, the material stuff was already stated, but to Ms. Ganderski's point earlier, the agenda was posted Friday. Also, the clerk's office maintained a public database where folks could see, all of the petitions and the objections, and it was posted, within minutes of the objection coming in. So, any candidate who would have suspected, or, I think most candidates went to that spreadsheet to see what objections were or were not filed against their candidacy.
So I guess then my final, and I appreciate the points, I appreciate the testimony. And I guess my final argument in rebut to that, and I'll just let the record stand as it is that so far I've heard a lot of arguments from the city and from the alderman's attorney about policy matters and about how this is a crazy time and we should allow the city leniency because we're on an expedited basis, and we should maybe overlook the requirements of due process and actual service because, again, it's an expedited process. I'm wondering why the same doesn't apply for the petitioner, Mr. Young, when it comes to some of these objections that were raised, and even just his request for a brief continuance to allow for a response. It seems if we're going to be fair here from a policy or practical matter, we should at least allow Mr. Young the same courtesy to get his response in order to allow as a council to review the objections and to have a very limited amount of time to address these.
Mr. Dale, if I move a motion for continuance, I don't know if would pass, but if I move that motion for continuance on Thursday morning at 9 a.m., are you willing then to drop the argument about, hey, we weren't served, or are we still going to be fighting that argument as opposed to the arguments of the objector about whether it was properly bound, whether the signatures are valid and all of that?
It would be, of course, up to Mr. Young since it's his decision to make, but if he were to direct me that he would drop that objection, I, of course, would drop that objection.
And then we would focus on Thursday morning on rebutting the objections of the objector.
Correct.
Which is about serving somebody.
Correct.
Eric, do you support that, Eric?
I do. Yes.
Okay.
Mayor Hagerty, before you make that motion, there are a few things that I would like to clean up today. It'll maybe save Eric Young and his attorney some money. So before we can, I'm willing to vote for that on one of the issues in particular. But if there are a few things that we can clean up before that motion, specifically objection number 4 through number 2, objection 1 can stand and we can continue on that. But if you're fine with that.
I'm not. I'm moving this whole case to Thursday and to hear all the objections. That's where I am. So let me move my motion. I'm going to move a motion for continuance for 9 a.m. on Thursday morning for the case 20 MOEB-EV-06, Catherine Whitcomb, et cetera, versus Eric Young. I will also, let me ask this question. Does the same apply, Council Dale, to the other case of Miles Davis versus Eric Young, or were you served on that one?
I don't think we were ever served on either of the cases. That being said, if Mr. Young again is willing to waive the issue of service, then we could represent him on both cases and waive that issue of service.
Yeah, I was not served for Miles Davis, so I'd like to move that to Thursday as well.
All right, so I'm gonna move a motion for continuance of item number 7, the Miles Davis versus Eric Young, and number 10, Catherine Whitcomb versus Eric Young, for Thursday morning at 9 a.m. Alderman Rainey, you're muted.
Second.
Okay. All in favor of moving these two?
Just discussion. I really do think before we vote on this, it's prudent that there are a certain number of objections here that we could just clear up today. I think counsel for Mr. Young may not be opposed to clearing up the objections, number 4 through number 3 on the Whitcomb petition. I think that would help expedite the process even Thursday if we cleared some of those objections.
I have no objection. I have no objection.
I don't think it's expediting. I think. it's-
Well, we have a motion and a second, and then there was discussion. So are we
Yeah,
voting?
that was the discussion. Any further discussion on this?
May I speak for a moment? I believe this also refers to Mr. Davis. Am I understanding the motion correctly?
Yeah,
Yes.
correct.
So this is Ed Mullen again on behalf of Mr. Davis. I am perfectly fine, and I believe it's appropriate to give Mr. Young the opportunity to brief this and respond. I would just ask that if we are moving the entire case to Thursday, whether the deputy clerk will be here on Thursday for me to get the same testimony that Mr. Foster did, or whether we need to take care of that today.
Mr. Gomez, are you present? Please unmute yourself. Are you able to be present Thursday at 9 a.m.?
That's fine, yes.
Okay, then I have no objection to moving the entire thing to Thursday. I believe that's appropriate. Thank you.
Thank you, Mr. Mullen.
And may I be heard, Mayor Haggerty?
Sure.
The one concern I have, and this may be something that you're going to take up next, is it sounds to me as though Mr. Dale plans to submit a paper in opposition, which is fine. I think we ought to follow a similar schedule, giving me a chance to respond to his paper in opposition. So similar schedule to what was discussed on that other case.
Thank you. I agree. And again, I think the written sort of arguments will help, which we received from you and the objectors, all the objectors. We haven't received from Eric Young and his attorney. So Ms. Gandersky, can you just set the schedule for these attorneys so they know when to have certain paperwork done once we pass this motion, if this motion passes? So any further discussion on this motion of a continuance? Seeing no further discussion, all in favor?
Mayor, I'm sorry, I think you had raised something regarding objections 2 through 4. I wanted to hear what that issue was.
Yeah,
before.
yeah. Is that Mr. Dale? Is that Attorney Dale?
Yes.
Yes. Yeah, there were, I think it's prudent. Some of these objections, I think we can clear up today and save some time and some maybe money for Mr. Young, because at face value, some of the objections are can be cleared up. So if I could be allowed to go through just 3 through or 4 through 2, and then leave 1, the binding issue, to be continued.
I'm not prepared. I am supportive of a motion to continue this entire case, not to take parts of the case today and then parts of the case on Thursday. I want the whole case or nothing.
That was the motion that was seconded. So is there a vote on that motion?
Yes, let's go ahead and we're going to vote. Alderman Rainey.
Aye.
Clerk Reed.
No.
All right, Mayor Haggerty's an aye. All right, both of the cases, which is number 6 on the agenda, number 7 on the agenda, Miles Davis versus Eric Young, and number 10, Catherine Whitcomb versus Eric Young, has been continued to Thursday morning, 9 a.m. Ms. Gandersky, could you please just lay out the schedule for the attorneys in terms of when they have certain concerns?
Counsel Mullen, Counsel Foster, and Counsel Dale, any responsive pleadings to the objection are due tomorrow, December 8th at the close of business. And please email that to the Clerk Reed has indicated he will accept service over email given the pandemic, and I would like to be emailed as well. Luke Stowe, can you put my email address in the chat box, please? And also, again, the clerk's email address in the chat box so that council can obtain that information. And then please make sure you serve each other, all opposing parties as well.
Correct. Your email and Clerk Reed's email are in the chat. Mr. Dale, could you give me your email, please? And I will give you mine. I don't know any other way to do that.
I'm sorry.
Your email address to serve?
Absolutely. It's D Dale. So the first initial of my name, last name, D Dale at Staub, STAUB, Anderson.com.
Okay, and my email is ed, MULLEN, law @gmail.com.
Yes, and you have my email already in the papers, Mr. Dale, but I'm happy to give it to you again. It's david.foster@ed.gov. at retiredpartner.lw.com. But it's right in my signature block.
All right, very good, Mr.
And
Foster.
clerk Reed, for the record, what is close of business tomorrow?
5.
And so 5 p.m. tomorrow is when the briefing from Mr. Dale is due. And then when would you like the replies from Mr. Foster and I?
We haven't set a schedule for replies. If you are to file a reply, let's schedule it for close of business, December 9th, 5 o'clock.
Thank you.
If you want to file a reply.
And counsel, may I file my appearance at the same time I file my response, or would you prefer my appearance on file today?
I would prefer all appearances on file today, please.
Very good. I will take care of that.
Do you have a form for that on the website, or do you just want us to file, just write up an
You
appearance?
can just file, you just write up an appearance form.
Okay, we can do that.
All right. Okay.
I do appreciate the board and the mayor taking my late appearance on this very late notice. I do appreciate the time. I want to make sure that that's clear. Thank you very much for the opportunity.
All right. Thank you, Mr. Dale. Thank you to all the parties on that. All right. So we have 3 cases that have been continued right now to Thursday, 9 a.m. We're now going to move to item number 6 on our agenda, which is case number 20-MO-02, which is Willie L. Jefferson versus Rebecca Mendoza. I'm going to ask Ms. Gandersky if she'll oversee the proceedings of this case.
Good morning. Mr. Mullen, please again state and spell your name for the record and indicate who you are representing.
Ed Mullen, M-U-L-L-E-N, on behalf of the objector, Willie Jefferson.
And Mr. Mullen, do you at this time intend to call any witnesses?
Yes, we would call the deputy clerk and possibly the candidate as well.
You're speaking about Ms. Mendoza?
Yes.
Okay. Deputy Clerk Gomez has already been sworn for the record. Deputy Clerk Gomez, you are still under oath, so just remember that. Ms. Mendoza, please state and spell your name for the record, and please at this time indicate if you have an attorney. Ms. Mendoza, are you there?
Yes, I am. Hi, good morning again. Rebecca Mendoza, R-E-B-E-C-A-M-E-N-D-O-Z-A. And I do not have an attorney with me at this time.
Okay, do you intend to call any witnesses today?
Yes,
Okay, who do you intend to call?
Mr. Gomez.
Okay, Mr. Gomez again has been sworn and he's under oath and he is present today. I'm going to ask, just to be expeditious, Ms. Mendoza, do you have any motions to make today before we begin?
Well, I would like to motion to subpoena Mr. Gomez.
Mr. Gomez is here. He does not need to be subpoenaed. He's here today.
Okay. Well, then no.
Mr. Mullen, do you have any motions before we begin?
I do not.
Okay, I'm going to ask this just to be clear. Are the parties ready to proceed this morning?
Yes.
Yes.
Okay, perfect. Ms. Ruggie, please set the clock. Mr. Mullen, you'll have 10 minutes. Ms. Mendoza, you'll have 10 minutes in response, and then let's set a 2-minute reply thereafter. If there's any witnesses called, the opposing party will have the opportunity to cross-examine the witness that has been called. So let us begin. Mr. Mullen, you have the floor.
Sorry, excuse me. Sorry. I do want to call an additional witness.
And who is that?
Miss Carrillo.
Okay, Ms. Carrillo, are you here?
I think I saw her leave earlier.
Okay, if Ms. Carrillo wants to dial back in and at the time you want to call her, we can swear her in as a witness for you, Ms. Mendoza. Is that okay?
Yes.
Okay. All right. Mr. Mullen.
So before we begin the time, if I may deal with a housekeeping issue, it is standard normally for the board to introduce as exhibits the petitions, the objection, the service of the call, and the rules of procedure for the record. So I would ask that the board do that, introduce the original petitions as an Exhibit 1, introduce objector's petition as Exhibit 2, introduce the service and call as Exhibit 3, and introduce the rules of procedure as Exhibit 4?
Yes, or go ahead, Ms. Kandersky.
That's
I'll
fine.
make that motion. So I motion to introduce the original, the petitions that were filed. I think Mayor Haggerty should have that. It's within the city's building. I also motion to, as Exhibit 1, as Exhibit 2, I motion to introduce the objectors, or the verified objectors petition filed with the clerk's office as Exhibit 3. I motion to enter the rules of procedure. And I forget, Exhibit 4 is, we've got the objectors petition, the petitions, the rules of order, and then the call of order, the call to order of this meeting as Exhibit number 4.
Okay, is there a second on that motion?
Second.
All in favor?
Aye.
And do we have the original copy of the petitions as they was served available?
The board was emailed the original copies of everything, so that they should all have that.
Right, but in terms of the showing how they were bound or not bound, is that available for now or not?
It should be. It's Deputy Clerk Gomez is within the city building, and those documents are there as well. So Deputy Clerk Gomez, if they are not already with Mayor Haggerty, maybe we can just run them upstairs to Mayor Haggerty.
Sure, Clerk Reed, if you give me a moment, I'll run that up to Mayor Haggerty right now.
All right, perhaps we can take a brief 3-minute recess.
Okay.
Sure.
Sure. I make a motion to recess until 10:26.
Second. All in favor of recessing? Aye.
Aye. We have to do a roll call because of the governor's.
I think we're fine.
Sure. All right.
Okay, I'm just going to ask the board when you're back, please start your video again so that we can see you. Okay, I show the time is now 10:29 a.m. I show Mayor Haggerty, Clerk Reed, and Alderman Rainey are back. Ms. Hickey, I believe we are back on the record.
Yes. Yes.
Okay, recalling 20-MOEB-EV-02 Jefferson versus Mendoza. I believe that a motion was made to move all exhibits 1 through 4 into evidence today. There was a second and a vote on that. Mayor Haggerty, have you received the nominating petitions?
I did. I reviewed the original nominating petitions. They're with Mr. Gomez right now, but he brought them up to my office and I reviewed them. And he presented them as he claims they were presented to his office when they were submitted.
Okay, so Mr. Mullen, the case in chief is yours. You have 10 minutes. Are you ready to proceed?
Yes. Is Mr. Gomez back on the line?
He is.
I am.
Good morning, Mr. Gomez. Do you have the petitions in front of you at the moment?
Yes, I do.
Okay. Can you show those to the video, please?
Yes. Give me 1 second.
Okay. And what is your current position with the city of Evanston?
These are the petitions. I'm the deputy city clerk.
Okay. And in that role, do you have any role in accepting petitions and nominating papers for candidates for offices in Evanston?
Yes, I'm the one that accepts them.
Okay. And did you accept the petitions that are in front of you from candidate Mendoza?
Yes.
Okay. And are the petitions as they are in front of you now in the same state as they were when they were filed?
Yes.
Okay. And can you describe whether there is anything fastening those petitions together?
There is not.
Is it in a binder?
No.
Is it stapled?
No.
Is there a binder clip or paper clip or any other type of fastener on them?
No.
And that is how they were presented to you when they were filed?
Yes.
And did you have any conversation with Ms. Mendoza when she filed the petitions?
Not to my recollection, no.
Okay. Did you tell Ms. Mendoza that she did not need to bind the petitions to file them?
No.
Did you take a photograph of these petitions when they were filed?
Yes.
And have you had an opportunity to review the objection that Mr. Jefferson filed against Ms. Mendoza's candidacy?
I have not.
Okay. Is it possible for me to share my screen, or is that not allowed on here?
Are you intending to show the objection?
I'm intending to show the exhibit 1 to the objection and ask him if he took that picture and authenticate it for me.
Yes, please go ahead and lay the foundation, Mr. Mullen.
Did you take a photograph of the petitions when they were filed?
Yes.
Okay, and did you, where are those photographs stored?
It's on my work Google Drive.
Okay, and have you made those photographs available to the objector in this case?
It's been made available to the public, yes.
Okay. And so I'd like to share with you the objector's objection and show you Exhibit 1. Oh, no, this is not it. Pardon me. For some reason, it's not wanting to share it. Do you have the objection in your possession, Mr. Gomez?
I do not. Not currently.
Mr. Mullen, are you trying to lay a foundation for the objection?
Yeah, I wanted to lay a foundation for the photograph of the petitions, but I think his testimony as to how they were filed is fine. So I have no further questions for Mr. Gomez.
Okay. Before we, I'm going to hit the stop timer just for a second. We're going to pause. Ms. Mendoza, do you have any cross-examination for Mr. Gomez? Ms. Mendoza?
Yes, I'm sorry, I was unmuting. I would just like to remind Mr. Gomez that he is under oath.
Wait, before you begin, I don't think we've sworn you in. Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Okay, let the record reflect Ms. Mendoza has been sworn in. Ms. Mendoza, Mr. Gomez has been admonished, he's under oath. So if you have questions, let's just get to it.
Okay. Mr. Gomez, when I came in with my paperwork, I asked you if you had a stapler. And you said, no, I do not have a stapler. I then started walking away and looking through my pockets there was fasteners on the table. And I started looking through my pockets to find a pen or something to perforate my papers. And you said to me, that's okay. You don't need to do it. You can just give them to me as is. Did you not tell me that it was okay to turn them in as is?
I did say that you could turn them in as is.
It was my intention to staple my petitions. And at that time, there was no stapler on the table. This is a separate location. When he told me that, I naively assumed that he would at some point staple them. I assumed that by him saying, it's okay, you can turn them in like that.
Ms. Mendoza, I'm going to stop you. This is your time to ask Mr. Gomez questions based on his testimony, not to make your argument. You'll have time for that.
Okay, well, he just told you that it was okay that I turned them in as is.
So any other questions for Mr. Gomez?
No.
Okay, no more questions for Mr. Gomez. Mr. Mullen, I'm going to restart the timer.
Okay.
And you can do any follow-up to that line of questioning.
So Mr. Gomez, did you tell her it was legally sufficient for her to file the papers without binding them?
No, what I meant by my comments is that anyone is welcome to turn in the petitions however they see fit.
Okay, and did you tell her when she turned in the petitions that they were that the way they were bound complied with Illinois election code?
No.
No further questions.
All right. Since there's no further questions, and I'm going to ask Ms. Mendoza based on that line of questioning, just to be fair, do you have any brief follow-up just on that line of questioning for Mr. Gomez?
I do not.
Okay. And Ms. Gomez, do you have I'm sorry, Ms. Mendoza, do you have an email address that I can send you something to right now?
Yes, I do.
And what's that email?
It's Becca Men, BECAMEN @me.com.
At me.com. So BECAMEN at me.com.
Correct.
Okay.
You're muted.
Mr. Mullen, you've got 4 minutes and 16 seconds. Mr. Gomez, I think the line of questioning for you is done. Mr. Mullen, any other witnesses to call?
I would like to ask Ms. Mendoza a few questions.
Okay, Ms. Mendoza, Mr. Mullen would like to ask you a few questions. You've been
Point of order, point of order.
Alderman Rainey.
Mr. Mayor, when we have people participating in a case, I think we need to see them. Mr. Mullen is.
I would like to be on video. I'm not allowed to open my video, so someone would need to.
Why is that?
There we go. There we go.
There you are.
Thank you.
Permission to.
Thank you. Thank you very much. I appreciate that.
So do I.
Thank you, Alderman Rainey. Okay, Ms. Mendoza, you've been put under oath. Mr. Mullen wants to call you as an adverse witness. Mr. Mullen, you've got 3 minutes and 55 seconds.
Thank you. So, Ms. Mendoza, you said when you were in the clerk's office that you were looking for a stapler and you were looking for something to fasten the petitions together. Why were you doing that?
Because I know that it's required.
Okay, no further questions.
All right, Mr. Mullen, your argument is done. Unless you want to make any additional arguments, you have 3 minutes and 30 seconds left. Would you like to make any other points?
Yes, I'll be very brief. The objection cites an appellate court case from the Illinois First District, which is binding on this electoral board, that says the requirement that the petitions be fastened in book form securely when they are filed with the board is determined by a standard of strict compliance as opposed to substantial compliance, and is a mandatory requirement. And if the candidate fails to comply with that requirement, their nominating petitions and their papers are not valid. Ms. Mendoza has stated to the board that she was aware of that requirement. Beyond that, there is a case that was decided by the Chicago Electoral Board, which I have sent to the clerk and Ms. Gandersky, as well as to Ms. Mendoza. And that is the Valentin case, where very similarly, the clerk accepted the petitions, but the electoral board said that the clerk's acceptance of the petitions did not make them legally valid under the requirements of the election code and the case law, interpreting the requirement of strict compliance under the case law. In addition, what I've provided to the board, as well as Ms. Mendoza, is from the Cook County Clerk's Office, a summary of what is required for apparent conformity, which is the absolute minimum bar that petitions must pass in order to be accepted by an election authority. And the apparent authority or apparent conformity requires that the petitions be bound. So this is not a complicated issue of law. It's a very simple, this is the minimum standard that petitions need to be filed in order to be accepted by the Cook County Clerk, is that they need to be bound. So it is our request that this board follow the Illinois Court of Appeals ruling and judge Ms. Mendoza's petitions on a strict compliance standard. And under that standard, she has admitted she was aware that they were supposed to be bound and that they were not filed in a bound form, and therefore her petitions are not be valid, and her name should be stricken from the ballot.
Okay, very good. If the board is so inclined, I will reset the clock. Ms. Mendoza, you have 10 minutes to present any witnesses and respond accordingly.
And the board, I'm sorry, Ms. Gandersky, for a point of order, the board will have an opportunity for questions after both parties give their testimony there.
Absolutely, Clerk Reed.
Okay, thank you.
Ms. Mendoza, you may begin. You can start your argument and you can call any witnesses. If you wish to call a witness, we'll call them and swear them in, and you can ask them any direct questions.
If Ms. Carrillo is back on, I would like to call Ms. Carrillo.
I'm here. This is Shelly Ann Carrillo.
Okay, Ms.
Hi,
Carrillo, I'm going to ask that you turn your video on, please. All right, there's Ms. Carrillo. Ms. Carrillo, please state and spell your name for the record.
Shelly Ann Carrillo, SHELLEYANNCARRILLO.
Ms. Carrillo, please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Let the record reflect that Ms. Carrillo is placed under oath. Ms. Mendoza, she is your witness.
Hi, Ms. Carrillo, it's nice to meet you.
Hi.
Hi. So I know that I believe that you were in the room when I was attempting to submit my paperwork, and I would appreciate if you were able to recap me attempting to bind and asking the clerk if he had a stapler and looking and leaving to go bind my paperwork, and then being told by the city clerk that it was okay to
Deputy
submit
Clerk.
my paperwork as is.
Back to this question, it's leading and argumentative, and if you could just ask what Ms. Carrillo observed. that would-
Yes, Mr. Mullen, your objection
Yes,
is the rules of evidence are loosely construed here in an effort to help Ms. Mendoza. Ms. Mendoza, it's better if you just ask Ms. Carrillo direct questions. For instance, was she there with you when you turned in your petitions? What did she observe? Ask your questions in a manner that will allow Ms. Carrillo to give an open-ended answer rather than directing her.
Thank you. Ms. Carrillo, are you able to recap for us what you saw as when I was turning in my paperwork?
Yes, I was there when you were attempting to file or to bound and file your paperwork. I do remember seeing you ask for a stapler, and I do remember hearing Mr. Gomez say that it was okay for you to turn in your paperwork as it was.
Thank you.
Do you have any other questions for Ms. Carrillo?
No, that's it.
Okay, I'm going to stop the timer so that we preserve your time. Mr. Mullen, do you have any cross-examination for Ms. Carrillo based on that testimony?
So Ms. Carrillo, did you hear the entire conversation between Ms. Mendoza and Mr. Gomez?
I heard most of it.
But you didn't hear all of the conversation.
Well, I was staying at a distance because of the virus.
Okay, so
I did catch a few things.
okay, and were you also doing something? Were you also in the office to do something yourself?
I was there to file my papers as well.
Okay, so you were doing something while you were overhearing part of the conversation. You were focused on filing your.
I was waiting. I was there for that purpose. I was waiting. The filing was not happening at the time. There was only one person there to accept the paperwork.
Okay, thank you.
Okay, Ms. Mendoza, based on that brief testimony, do you have any follow-up questions for Ms. Carrillo?
I do not.
Okay, I think we can excuse Ms. Carrillo then as a witness. Do you have any other witnesses to call?
I do not.
Okay, restarting the timer. You have 7 minutes and 18 seconds left to make any further arguments.
I would like to note that I was not served. I've been in quarantine and have not left my house for 12 days. I found out about the hearing last night at about 4 p.m. on social media. So I did not have time to, this is all that I had time to prepare, and I did not have details of the serving papers. So if possible, I would like to know where the sheriff attempted to deliver the paperwork, because I have not left my house in the time that I've been in quarantine.
Okay, Ms. Ruggie, are you there? Can you please turn your video on?
Yes, 1 second. Let me look it up.
Ms. Ruggie, again, for the record, is Assistant City Attorney who went to the Sheriff's Office last week, Thursday, December 3rd. She has previously testified, and she will look to see where the sheriff has attempted service.
Just as Ms. Ruggie's looking into that, as a point of order or question for Ms. Gandersky, is this just for the order of things? Should this have been a motion toward the beginning when you requested if there are any?
Yes. Again, I have explained to the parties present that if there's any motions to be made at the beginning, to please do so. I asked that question. I'm also going to state that, people are here today. Appearances people are present and appearing. No motion in this case was made to continue. I asked if there were any motions, so I'm just going to advise the board of that accordingly.
And this is Alexandra Ruggie, Assistant City Attorney. So I pulled up the Cook County Sheriff's site, and it says that an attempt was made at 2008 Keeney Street on 12/4, but that no contact was made.
That's not my address.
I believe that's the address that we had on the papers. So.
You have the papers at hand.
Mendoza.
Okay, so sorry, I apologize about that.
I couldn't hear that. What was that?
There's another candidate running named Stephanie Mendoza, and it sounded like the papers were served to Stephanie Mendoza, not Rebecca Mendoza, which is a problem.
That's a problem.
That is.
That indeed is a problem.
Yeah.
Well,
2122 Ashland, that's where they should have been.
So this is an error by the Sheriff's Office. Ms. Mendoza, you're here today. We've conducted the hearing in the majority. If we were to continue the case, I would ask, what would you seek to have the continuance on? What would you like to do?
I would like for you to dismiss the case.
Okay, that's not the question. The question is, if you're claiming that you weren't properly served. I asked for the motions up in
It's been
advance.
confirmed I wasn't properly served.
Let me finish what I have to say. There's a court reporter trying to take down information, and she can't take down both of what we're saying at the same time. You stated you weren't properly served. Ms. Ruggie confirmed that the Sheriff's Office served another party with the same last name improperly. I asked if there were any motions at the beginning of the hearing. You did not make any. We've conducted almost a full hearing now. So if this matter were to be continued, what would you like to continue it for? In other words, what are you feeling that at this time you haven't been able to accomplish at this hearing that you would be able to accomplish a few days from now?
I mean, I would be able to see counsel.
All right. Well, again, Ms. Mendoza's now making a motion to obtain counsel to continue her case. I don't know.
Yeah, I would just say, Kelly, I am partial to Ms. Mendoza's request for continuance because it's hard. I mean, Ms. Mendoza is not an attorney. And so when you ask all these things up front as an attorney, there's a bunch of attorneys speak. I'm not an attorney, and that's why I've sort of asked you to run this, but there's a lot of attorneys speak. And I don't think that we can expect necessarily that, residents or people who are just interested in running for office understand that. So when you say up front, are there any motions? I don't know if I was just representing myself. I went through this 4 years ago when I ran for mayor, and, I had an attorney, thank goodness, because otherwise I'd probably just try to be answering these things. And so, which I appreciate that Ms. Mendoza has been doing today. But I think in fairness, because of the mistake that was made, and I'm not sure that, by the way, that I can't say that was the Sheriff's Department's mistake or the City of Evanston's mistake in giving the wrong address to them. I don't know, but clearly we know where where the server went, and it wasn't to Ms. Mendoza's residence. And so I would move a motion to continue this on Thursday morning at 9 a.m., giving Ms. Mendoza time if she wants to seek legal counsel and
Second.
return then at time.
Second.
I oppose that motion for the
Thank-
record.
Thank you, Ed. All right, so seeing no further discussion, all in favor of continuing this on Thursday at 9 a.m.?
Aye.
Right. So we'll do that. And then Kelly, why don't you talk to Ms. Mendoza and Attorney Mullins just about what the timeline would be, especially if Rebecca wants to go find an attorney, what
Okay.
timeline?
I think we, in fairness to everybody else, we should keep the same schedule. So any response to the objection should be filed by close of business tomorrow, which would be 12/8 at 5 p.m. And then a reply thereafter, if necessary, on 12/9 at 5 p.m. by 5 p.m.
Okay.
And then the hearing will be 12/10. And then I would like to say for the record, if there are any other parties who are contesting that they haven't been served and would like a continuance, please let us know that before we begin. I think this is the second or third time I've made the announcement. I appreciate what you've said, Mayor. So if there's any other parties that feel that they have not been served or would like an attorney, please let us know before we begin your case.
All right. Thank you. So Attorney Mullins, and thank you for your efforts today. And Rebecca Mendoza, thank you for yours. And we'll continue this on Thursday morning at 9 a.m.
Thank you.
Thank you. All right, we're going to move now to the next case, which is item number 8 on our agenda. This is case number 20-MOEB-EV-04, which is Allison Harned versus Jane Grover. She has submitted petitions. Jane Grover has to run for city clerk of Evanston. Allison Harned is represented by Ed Mullins on this. So why don't we first move, and Kelly, perhaps you can cite them from a legal perspective to enter into the record all of the official documents.
Yeah, so first I'm going to ask.
If Clerk Reed has it, we'll let Clerk Reed enter those all in.
Before we begin, though, I would like Ms. Grover, are you here? Or are you here represented by counsel?
You're muted, Jane.
Yes, thank you, Ms. Gandersky. I am here and pro se today.
Okay, Ms. Grover, before we begin, I'm going to swear. Are you a licensed attorney?
My attorney license for the last 20 years has been inactive.
Okay, I'm going to swear you in then. Please raise your right hand. Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, great. Let the record reflect that Ms. Grover has been sworn. Ms. Grover, Mr. Mullen, before we begin, are there any motions you want to make to continue this matter? Ms. Grover, any motions to obtain counsel? Any contest of service? All right.
I did have a question, Ms. Gandersky. It would be about the service of the actual objection. I did receive service on Friday of the call and the agenda for today, and I have obtained the objection. I just wonder if the board's rules make any provision for actual service of the objection.
The objection should, Mr. Mullen, you're muted.
I'm sorry.
So were you trying to say something, Ed? I think.
No,
Ms.
I was
Gandersky.
not. There's someone at my door. I was trying to tell that I was doing something. I apologize.
Ms. Ruggie, was Ms. Grover, did the packet include the objection from the sheriff's office?
So the packet does not include the objection from the sheriff's office. Per statute, it just requires service of the call and the agenda. But the objection was posted on the city's website with the agenda as part of the OMA requirements.
Okay, based on that, Ms. Grover, do you have any other questions?
Just a suggestion that in the future, there ought to be a more formal way of ensuring that candidates receive copies of the objection. Thank you, Clerk Reed, for posting it on the clerk's website. Thank you for the heads up that it was there, but for other candidates, prospective candidates, they may not know to do that.
I'm going to note, it was also posted on the city's website under the electoral board. The agenda and all the objections were posted there.
It's just the notice to prospective candidates of where to find it. Thank you.
Thank you. All right, clerk, having no motions been made at this time, clerk Reed, do you want to minutes?
But I was, excuse me, Madam Attorney, I will be filing a motion to dismiss, to overrule the objections and to dismiss the objection.
Okay, so we should, again, we've set a briefing schedule for other candidates, board members. My recommendation to the board would be to follow the same schedule.
Agree. So Ms. Gandersky, though, do we even want to enter the records that we have to date into the documents that we have to date into record? Or are we saying that we will continue this on Thursday morning at 9 a.m., giving the petitioner the right to file a motion to dismiss?
If we move all the documents today, we don't have to do that again on Thursday. So you may want to do that today.
So let's do that first. Clerk.
Yeah, I'll move to enter the original petitions as Exhibit 1, the petitions of Jane Grover, who is seeking the office of City Clerk. I will move also to enter the verified objectors petition as Exhibit 2. I will then move to, as Exhibit 3, include the call to order. And as Exhibit 4, the service. I think it's the notice of service, or the
Okay.
Ms. Gandersky, is that proper? Is it Exhibit 4?
Yes, you're talking about the service process?
Yes.
Yes.
Okay,
All right.
I'll second that.
Okay, all in favor?
Aye.
Is there, okay.
All right, so that being said, Ms. Grover, the same briefing schedule we've been setting, if the board is amenable, is all responsive pleadings will be due at close of business tomorrow, so 12/8 at 5 p.m. And Mr. Mullen, your reply will be due 12/9 by 5 p.m. And we will see you all back at 12/10 at 9 a.m.
All right, so just here's some, I'm sorry, Jane.
I just want to make sure that I have Mr. Mullen's correct email address. And is there anything else, Ed, that you would need from me?
Just the motion. I would need your email as well. Mine is edmullenlaw@gmail.com.
All right, and again, I'm going to ask that everybody serve me as well as the clerk with courtesy copies so that we can get that all to the board.
And your email?
My email, Ed, is blanchegrove@comcast.net. So that's B as in boy, LANCHGROV@comcast.net.
All right, so then I'm just to take care of official business, then I'm going to move to continue case number 20 MOEB-EV-04 Allison Harned versus Jane Grover to this coming Thursday at 9 a.m. Is there a second?
Second.
All in favor?
Aye.
All right.
Thank you.
So, all right. Thank you to both the parties. All right, we're now going to move to the last case on our agenda today that we haven't discussed, which is item number 11, which is case number 20-MOEB-EV-07, which is Evie Krause Russell versus Eleanor Revelle, who is a candidate or submitted petitions for running for 7th Ward Alderman.
Okay.
Good morning, Andrew Finko for the objector, Evie Krause Russell.
Mr. Finko, can you please turn your camera on?
I have to get permission if possible.
Mr. Stowe, can you grant him permission, please? And then counsel for Alderman Revelle?
Michael Kreloff, I filed appearance and I also need permission for the video.
Okay, we'll wait for Mr. Stowe to grant you permission.
And then Kelly, I'll let you move through the proceedings.
All right, we have the objection on file. We have a motion to dismiss on file as well. Mr. Finko, have you received a copy of the motion to dismiss?
I did receive that perhaps an hour ago or so,
Okay,
and I would request an opportunity to file a response.
all right. So I don't think we have any contests for service since we have counsel here appearing and a motion to dismiss. So again, my recommendation to the board will be to set the same briefing schedule as we have for the other parties and continue this matter to 12:10. Briefing schedule again would look like responsive pleading due tomorrow, close of business 12:08. And any reply thereafter due close of business 12:09 by 5 p.m. with the hearing to take place on the morning of 12:10 at 9 a.m. If the board is so amenable, would someone like to move and second?
I'll move
I
a
will
motion. Okay, go ahead, Clary.
I'll move that motion.
Is there a second?
Yeah.
Is there a second?
Second.
Okay. All those in favor?
Aye.
Aye.
All right.
Alderman-
And then
Okay.
Alderman Rainey, is that an aye from you?
Yeah.
All right. And then Clerk Reed, why don't we just for brevity move all the exhibits in on this one as well so we don't have to do that Thursday?
Yes. I'd like to move the original objectors petition as Exhibit 1, the original petition as Exhibit 1, the original objectors petition as Exhibit 2, the call to order as Exhibit 3, and proof of service as Exhibit 4.
All right. Is there a second on that?
Second.
All in favor?
Aye.
Aye.
All right. I think that takes care of all of the cases on the docket today.
I have, excuse me, Ms. Kandersky.
Yes.
Andrew Finko speaking for the objector, Evie Cross-Russell. I have a couple of other questions or points I wanted to raise on this objection. Number one would be if it would be possible to have Deputy Clerk Gomez provide his photograph and testify on Thursday, and if candidate Ravel could testify as well on Thursday.
Deputy Clerk Gomez will be present on Thursday.
And could I have my video opened, please?
I'm sorry, who is this
This is
speaking?
Mike Kreloff, I'm sorry. I still need permission. I put on a tie. I need to use it.
Yeah.
Yeah.
Come on. Let's.
There we go.
All right, there it is.
All right, thank you. On behalf of candidate Ravel, and Mr. Finko, you're asking if I'll have her appear. I believe Ms. Ravel is on here and is available and will be asked to appear at the hearing. And maybe she's on mute. Let me just check.
I will be available on Thursday.
Okay, great.
Okay, and Mr. Deputy Clerk Gomez, I'm going to remind you to be present at Thursday at 9 a.m. and please have photographs. Let's do it this way. Photographs of all of the petitions that you've taken ready, and please be ready to share that on your screen as well so that we can just be expeditious on Thursday.
We'll do.
And I'll go ahead.
May I ask if it would be possible for the deputy clerk to email a copy of those photos that were taken on the filing date to me and to Mr. Kreloff ahead of the hearing?
I will do that.
All right, thank you.
As another note, if we are done with setting a schedule for this case, to make sure that we're moving expeditiously, Counsel Gandersky, in the event that the board in Ms. Grover's case does not accept the motion to dismiss and a records examination is requested, can we just be fully, aware of what steps we have to take to get that records examination with the county?
Absolutely. It's a great question. So my recommendation to the board would be to instruct Deputy Clerk Gomez to invite the interested parties to examine the petitions in person.
My apologies. So the county clerk's office has to do that. So I spoke to, Jesus Christ, why am I blanking on her name? Colleen Gleason. I spoke with Colleen Gleason, the Director of Elections. And so when we want a records examination, those records, those original signatures can only be verified at the county. And so we requested of the county.
Correct. And so what I'm asking is that, well, what I'm advising is that you have Deputy Clerk Gomez coordinate that with the parties so that everyone can be present at the same time to do that. They have the right to be present for that inspection.
But Kelly, that would come after the Thursday meeting, right? So there's no action we need to take right now with Eduardo Gomez, the deputy
That's
clerk.
Yeah, there's no action now, but just to make sure that.
And then on top of that, once there has been an inspection, I think Mr. Gomez should be present as well. He can write a report back to the board as to what was discovered at that inspection.
Okay. All right. Thank you, Clerk Reed, for bringing that one up, because that is one that's going to take some time. Anything else before we move on from the cases? All right.
I'm just going to make a point of order. The rules state that the court reporter does not transcribe public comment, but should come back on after public comment to transcribe any other business and adjournment. So I just want to make that note.
Thank you for making that point, Kelly. That's helpful. All right. Well, thank you to all the parties that came forward, for all of those that are petitioning to run for office, and all of those raising objections. We appreciate your time this morning. We're now going to move to public comment, which is item number 12 on our agenda. Luke Stowe, I didn't see if anyone had signed up for public comment. Could you let me know if that's the case?
There is no the form that I have access to.
All right, so there's no one that has signed up for public comment. Kelly, could you or Clerk Reed let the public know, because again, we'll do the same thing on Thursday. We'll have public comment at the end. If anyone wants to speak, I just want them to understand how to sign up for public comment.
Luke, can you give the instruction, please?
Sure. The form that I have access to is available through the clerk's website. There's a public comment form there, which is typically the form that people complete for city council meetings. And as of now, there were no public comment signups for this electoral board hearing.
Okay.
Maybe we can include a link in the agenda, since folks aren't as familiar with these meetings.
I think that's a good idea. We'll go ahead and do that. All right. So now we're going to move then to item 13, which is discussion of further MOEB scheduling, recess or adjournment. I think we've taken care of all of the scheduling and all the parties are aware of that. Is there a motion to recess this to continue this meeting on Thursday at 9 a.m.?
So moved.
Second.
All right. All in favor? We're going to do a roll call vote on recessing until Thursday morning, December 10th, 9 a.m. I vote aye.
Aye.
Alderman Rainey?
Aye.
All right. Thank you, everyone. This meeting has been recessed. Yes, Kelly?
Ms. Hickey, I'd like to order a copy of today's transcript on an expedited schedule, please.
Okay.
All right. Goodbye, everyone. Thank you.
Thank you.